Thank you very much. I'm Ted Claypool. I am a partner with the law firm of Womble Bond Dickinson, and I'm going to be moderating this panel today. We're very fortunate to have some of the top people in the country who are looking at and implementing AI solutions for their large law firms. And I'm going to let them introduce themselves and talk about what they're doing first, and then we'll get into a little more round robin discussion afterwards. So, Peter, why don't you start off?
Well, good afternoon, and thank you for inviting me to be part of this panel. My name is Peter Giovannis. I'm the Chief Innovation and AI Officer at McGuire-Woods Law Firm. Real quickly, my background, and I'll kind of tease you with what we're doing, and we'll take more of the panel to answer any Q's and A's. I started my career as a naval officer. I did 8 years active duty, went back to school, got my MBA. Think of that as chapter one. Chapter two then was a 20-year career in consulting. Toward the end of that 20 years, I went back to law school, got my law degree. For the last 7 years, I was head of data strategy, AI, and analytics at Winston and Strawn. At Winston, I also introduced Casetext CoCounsel to the executive committee, and we ultimately were one of the first law firms to sign on and start that. And then I started McGuire-Woods this August, and that was my kind of marching orders from the managing partner was they view artificial intelligence, specifically in the area of law, that we're at this kind of critical inflection point. And the thought process at the firm is at the end of this cycle, there's going to be law firms that have grasped it and understood the use cases and have used it for efficiencies and potentially competitive advantages for their clients, and others that kind of missed the boat, and we wanted to be more of the former. So my role is to kind of be that champion and kind of shepherd the law firm in with training and change management and implementing this new technology. And like I said, I think even more importantly, it's working very closely with the attorneys, both the litigators and the transactional attorneys, to instill kind of foundational knowledge of what the tool and what generative AI is capable of, working through the risks, the limitations, the ethical responsibilities, and then using their creativity specifically for their practice areas to come up with these use cases that will provide a cost savings for our clients or these efficiency gains, or in the best case scenario, right, a true competitive advantage for the firm and its clients. So happy to share our journey with us. I'll pass it over to Bill.
I'm Bill Garcia, Thompson Hines Chief Practice Innovation Officer. I work with the firm's practice innovation team, which is made up of specialized non-practicing attorneys, software developers, and analysts. And we develop new processes and technologies to drive efficiencies and collaboration within the firm. And importantly, to train our lawyers on how to use them. I also spearhead development of custom technologies that enable the firm and clients to streamline and better manage their legal operations. Prior to this role, I was a practicing lawyer at two international law firms, and then spent the bulk of my career as a practicing attorney in-house at Gannett, the newspaper and media company. I'd like to give you a little pre-seer overview of what it is that Thompson Hine is doing in the AI space. For at least 5 years, probably longer, the firm has used AI-enabled tools in a variety of contexts. The tools that we've used for years, and for the most part, these are tools that we built, rely on natural language processing, machine learning, and statistical analysis to drive algorithms. The existing AI tools, or the prior to fall of 2023 AI tools, fell primarily into three buckets of the practice of law, what we would call the business of law, and then personal productivity. Within the practice of law, we, like so many of the law firms, have been using e-discovery tools that use predictive coding. We've been using commercially available case analytics software that looks at federal and state dockets to give insights into how judges or courts might react. And we have been using contract analytic software to support our transactional lawyers on diligence and other review of non-litigation documents. Within the business of law, we developed two what we call fee predictors. They are statistical analytic tools that use AI algorithms to ping databases of cases in our history to give us insights into the effort that will be necessary to complete an engagement so that we can be better at budgeting and planning our work. As you may know, one of the things Thompson Hine is noted for most in the market is our mandatory budgeting policy, where many categories of our work require a budget in our system and require matter monitoring in our system, whether or not the client requests it. And then the final bucket of AI tools is personal productivity tools, and this is everything from natural language processing or machine learning assisted time entry to more recently emails and the like. With regard to generative AI, we've been looking at this for just about a year now, and I think our work has been divided into about half a dozen work streams. The first and the continuing is a survey of the landscape. As you know, if you're put anything more than a toe into the water with respect to generative AI, there's a lot going on out there. There are a lot of vendors. The landscape is both frothy and volatile. So we spend a fair amount of time evaluating vendors, evaluating products, trying to weed out the noise and the likely failures at the beginning of our process, so that those pieces of software that we don't think are going to have application within the firm don't get too far down the process. In parallel, we're developing use cases. We don't believe in buying new shiny objects just because, or just to keep up with public statements of some of our competitors. We want to understand where and how these tools might be used in the firm, and whether there are other more straightforward ways to solve the problem before deploying and acquiring advanced technology. So the first step is to make sure that any software meets our security protocols. We make a credible use case for it, and most importantly, we get commitments from users to take the project of evaluation earnestly and to have the interest, time, and energy to get trained on the software and to test drive the tools extensively. We create structured testing protocols, and I think that's a very important tip. There is a place in a pilot program to let the lawyers involved just play with the tools, but if they just play with the tools, you might find yourself not getting the kind of evaluation that is necessary to make what can be a pretty important and long-lasting decisions. So we try to create structured protocols for the evaluation to make sure that various aspects of the tool, as promised by the vendor, get vetted and get tested in our own environment. We're very mindful of the change management challenges that we face internally. So we're developing internal marketing and branding resources to accompany either firm-wide or practice group-wide launches. These are standard change management techniques: making the case for change, identifying champions, publicizing successes, and the like. We've also developed internal knowledge management sites to house general information about the use of AI in the industry and at the firm, as well as software-specific tools. As they're developed, these will house our internal quick reference guides and how-tos, so that we can widely disseminate the learnings from one practice group across practice groups and across the firm, so that we're not reinventing the wheel. Guidance and governance, huge issue. Creating a framework for governance for this new technology requires a lot of thought and a bit of prediction on how the future will unfold. In some respects, these are threshold issues because you can't really develop training on acceptable uses until there's agreement on what acceptable uses are. And that is something that is going to take more time than you might anticipate. And there are going to be a lot of opinions on that. So as you're planning an acquisition or a deployment, you should build enough time into your timeline to spend some time thinking about governance and guidance. Finally, we have a history of developing innovation tools internally. Our proprietary budget and work planning tool, and our fee predictors are two examples. So we continue to look at the tools and look for ways to deploy the tools beyond what the vendors envision. So those are our 6 work streams, and what we've been doing over the course of the last year. We have acquired and deployed a Gen AI agent associated with Kira, our document analytics tool called Smart Summaries, and it uses a private instance of Microsoft's OpenAI GPT.
Good, thank you, Bill. Peter, do you want to go in a little more detail about what you all are doing?
Love to. So as I alluded to, I started at McGuire-Woods in August. My first responsibility was getting the contract signed for Casetext Co-Counsel, and we started in earnest testing mid-September of 2023. Like I mentioned before, that's both the litigation department, that's the transactional attorneys. We also had interest from some of the paralegals, the legal research team, and also, believe it or not, the business of law. There were some use cases there as well. So as we were looking at this, and you've got to imagine, a very risk-averse law firm looking at this generative AI tool, we set up 2 phases of testing. So what we called phase 1, we had 100 licenses to distribute across the firm, and we made the attorneys basically sign an attestment saying no client data would be uploaded during phase 1. The rationale for that was really twofold. One, again, being extremely risk adverse, kind of starting off slow, understanding all the potential risk and liability that may lie with using these type of tools. But for us, I think the more important phase or consideration was the vendor had not completed all of their security audits, specifically the SOC 2 audit report. So we put a kind of a line in the sand just to kind of complete that story. December 22nd, they completed that audit. We met in early January with our security team, with our CIO, reviewed it with the vendor. We gave thumbs up to proceed to what we're calling phase 2, which will start for us actually next week. And phase 2 will allow our attorneys to use their professional judgment if they want to upload client materials. And we'll also be very cognizant if a client had, a notification, whether it was information going into the cloud, or they may have, we've had a couple, either opt out of using AI tools, and more often it's notify us if you're going to use AI tools. But I want to share a little bit of kind of our learning. So as we've done this, like I said, both litigation and transactional attorneys, in order for someone to get a license, we have asked 2 things. One is if it's an associate, that they also bring a partner to the table so that we have that leadership and we have some responsibility and some accountability from the partner. Not only that they know the associates using this tool during this early testing, but also that the learnings can be shared between the associate and the partner. And then the second aspect of that condition is that they attend one of the foundational trainings. And that's basically the 101. And we've been doing that training in conjunction with the vendor, typically once a week as we get new people kind of cycling in. And then we also ask at the end of that they share with us what their use case is. And what we found is more often than not, if we don't follow up with them, we're not going to get the testing. We're not going to get the involvement. As you can imagine, the attorneys are billing. We've already put one hand behind their back when we said, don't put any client data in there. So following up with them is really important. The next part of this that we found is there's a new term that's come into our vernacular. I'm sure you may have heard it now, prompt engineering. And what that's meant for our attorneys is it's a little bit of an art, a little bit of a science, but until you understand the ability to create a prompt correctly, you may not get the results that you intended. So it's something that we've continued to reinforce and train. And in fact, we're taking it to the next level. In February, we are doing a 1 hour workshop on prompt engineering for our attorneys. The little carrot that we're dangling in front of them is it will also be eligible for CLE in a number of jurisdictions. So we're hoping that will get them into it. The other part of this that I didn't anticipate, but has been very helpful is our insurer. We use ALAS, and I'm sure that's a common one across the legal industry, but they've also been very helpful in providing a kind of a starter kit around ethics and responsibilities for using generative AI. And we are holding a workshop on that as well. Now, we don't anticipate any problem or ever being audited, but again, I think it's just a great way of kind of protecting a little bit CYA of having all these different trainings done and these attestments by the attorneys that we're doing this. And again, my three favorite words that I've been preaching since I started at the firm, in a very responsible, ethical, measured approach as we're going about this testing and evaluation. The last part I'll share with, and I'll turn it back to you, Ted, is I love this creativity aspect, and I'll give you one example. I was talking to one of our litigators, and they had just gotten their license for the tool. They didn't know how they were going to use it. And the use case they said they were coming up with was next week they were going to be deposing the opposing counsel's expert witness. And they said they had a number of transcripts and Daubert motions and past treatises and articles that this expert wrote. And they asked, is there anything we could do with all these? And again, we're kind of making up the rules as we go along. We're playing this mad scientist. We don't know what's going to come out, but we have a lot of hypotheses. So in this case, the hypothesis was, what if we were to upload all those documents that you have related to this expert and let the tool, the generative AI, in this case, it's Casetext CoCounsel using OpenAI GPT-4, help us identify contradictions that this expert may have written or talked about in the transcripts or in the Daubert motions or in prior treatises. And I'm making this up, obviously. On Monday they said something was red, and on Tuesday they said it was blue. But if we're representing the defendant, that's really powerful if we can identify these contradictions. And this is an example of, again, having a hypothesis and being delighted at what the AI was able to present us and allow us to prepare for trial in a new way that we would have never been able to do other than reading through hundreds and thousands of pages and trying to keep it all in someone's mind. So I think 500 pages ago, they said the opposite, but this was a great tool. So Ted, I'll stop there. Happy to go into more detail or any pointy questions as we continue.
And we will have many. And we're already getting them from the audience here. But let's back up a little bit. I know that Bill, your folks have actually designed in-house some AI. Let's start with you, but I want to hear from Peter on this too. How do you make the decisions as to what is made in-house versus what is essentially purchased from a vendor? You are still muted, Bill.
Tried to be polite so that Peter didn't hear my siren behind me. Apologize. I think that's a great question. It's a continuing question that we had, whether the technology involved was based in artificial intelligence or not. I mean, we had the same question that we asked ourselves about our budgeting and work planning tool, which is not AI based. It's a question, really, I think, Ted, of what skill sets you have, what skill sets you can be reasonably assured you will continue to have throughout, and whether you can find individuals in your IS group who sort of get it, who understand what it is that you're trying to do. One of the beauties of the design of our budget and work planning tool was that we had a development team that just understood where we were trying to go, and much of what happened in the budget and work planning tool was a result of those folks. Contrast that, I think, contrast sort of standard natural language processing, machine learning algorithms with generative AI. I think that right now, with respect to generative AI, we're probably in general thinking that it will be more effective and less expensive than trying to build something ourselves if we buy a solution, just because the technology is so specialized. Those particular tools are so very complicated. They require a lot of training and testing. They need ongoing care and feeding to remain relevant. It's best left to professionals who are doing that full time. We've had several people want to purchase rights to our budget and work planning tool, and it's not for sale because we're not a software vendor. It's not what we do, and we need to focus really sort of on the core. So if I'm making this decision, if I'm analyzing this decision, the real question I've got is, do we have the horses to do this in a reasonable amount of time and to keep it reasonably relevant? If not, then we need to buy.
Good. Peter, I don't know that you guys do as much internal creation yet. I know you haven't been there that long, but could you tell us a little bit about what your thinking is there? And also, when you're looking at vendors, how do you select among the tools in a crowded market right now?
Yeah, and we'll talk about that because I think that's a really interesting point. So if you circle back to December of 2022, Casetext CoCounsel was obviously the first kind of legal generative AI tool out of the gate. So there wasn't the LexisNexis or the Bloomberg, or even you would say Microsoft Copilot now. But to your original question, build or buy, we actually add a third category, which is partner, which in this case of Casetext, I've done twice. So in addition to signing that contract with Casetext in December of 2022, I also negotiated that I'd have a seat on their advisory board to help kind of steer their roadmap and make sure that the use cases aligned with our practice areas and what our attorneys needed. And I took a page out of my same playbook. When I signed the contract in August of 23 for McGuire-Woods, I made the same request to keep the advisory board seat. So that's one way that I can kind of influence where the product is going, give them real live feedback of what our attorneys are sensing with the material and the tool, and have that dialogue back and forth. And I think that's invaluable to us. And that is a determining factor, is how easy is it to work with these vendors, and are they open or receptive to getting feedback from our either IT group or our attorneys, or that combination going forward. So I think that's really important. The other aspect of the build or buy is what's available in the marketplace. At my previous firm, I think I had mentioned I had won Legal Innovator of the Year, had built a really interesting tool that was used for business development. Also built another tool that was mining Twitter and looking for potential product liability cases before they were actually turned into product liability cases, and giving our attorneys kind of that early over the horizon view of what's happening, or even reputational risk for our clients. So those type of solutions don't exist from a vendor, but we're able to basically creatively work with our marketing or business development team, sense a need, and develop a tool to give the firm a competitive advantage going forward.
Bill, do you have any thoughts on choosing in a crowded marketplace?
Yeah, it's why I have my CIO as my partner, because we have had for years a formalized process for evaluating and adopting new technology that pairs the technical adoption environment with the practice group evaluation adoption environment. Essentially, it comes down to two questions that we sort of proceed simultaneously with. What can we do technically? How does it fit? with every other piece of technology that we have in the firm. Is this going to cause us to have to change other technology or change our other processes for the lawyers? And then, you know, what's the human element? What is it that our lawyers and clients will accept? If it is too complicated, they won't do it. There are many lawyers in this country who don't use Outlook to schedule, right? It's because it's too complicated. Well, it's not too complicated to use Outlook to schedule. It's pretty easy. But if it gets to be, if the lawyers perceive that using the technology is complicated and they have to learn one more thing, they simply won't do it. And so the human element evaluation has to be, in my mind, central. If technologically it won't fit, that's a automatic stop. But the human element, we need to evaluate just how big is the impediment, and can we train past the perception that the software is too complicated.
That's helpful to know. Sorry, I've got a guy with a gas-powered leaf blower standing about 6 feet away from me right now. I can't get him to stop. But yeah, I wanted to ask what you both talked a little bit about how you make your choices and what drives the decision for what products you use. Can either of you talk a little bit about if you get influence from your clients at all? I'm sure you get a little FOMO and interest from lawyers. We've talked about that, but have you either of you heard from clients asking you to look at certain technology in this field?
I'll take a crack at this, Bill. So again, I think because Casetext was so early out of the gate, there really wasn't options. But to your point, Ted, as of November, just 2 or 3 months ago, right, we're seeing competing products. So Casetext was bought by Thomson Reuters. Lexis came out with a tool called Lexis Plus AI. Bloomberg has an AI tool. There's another tool called Harvey.ai. So as we are going through a very thorough test and evaluation of Casetext CoCounsel, I've also let it known to our managing partner and some of our firm leadership is come the spring, which I don't know if that'll be March or April or May timeframe in Chicago, we will also do a very quick evaluation, kind of kick the tires on these competing products, because sometime before Q3, we kind of need to make a decision as a firm as to what is going to be our go-to tool for generative AI, and get beyond the 100 license and start thinking more on an enterprise, 1,000+ license, and then also think of all the consequences of how we're going to support that, whether that means a center of excellence or upskilling other people across the firm, whether it's the legal research team or the IT team, help desk, whoever it may be. So a lot of different implications. I do think because this is brand new technology in the generative AI spokes, we're just now at the point where there are 3 or 4 or 5 viable players, and we do need to make that firm-wide decision. And I would also say too, it may not be a single vendor. It may be a combination. It may be, I'm making this up, it may be Casetext plus Bloomberg or plus Lexis AI. Right now, I don't know. The other wild card is there is some thought process of, do you need to host your own large language model? And we can talk about that in a subsequent question if you like, and what the pros and cons are there.
I think I would urge caution in making the selection here, because I think you've got a real installed base problem. Okay, if we are looking at different pieces of successor pieces of software to handle various functions within the firm, and the challenge that you always have is you're changing the software on me. I just learned how to use it. Right. And now you've gone and changed it. The amorphous they are making my life difficult. Why are they doing this to me? Even if it's, even if it's a generation improvement in the software. And so I really believe that the change management aspects of the adoption of this software get undervalued in a lot of places. And you really need to think about the impact on your users when you're making these decisions. And if that means you go slow and you don't make a decision quite as fast because you're trying to understand those impacts a little bit better, then so be it. Because that's a lot less pain than 2 years from now saying we made a serious mistake and now we're going to blow up everything that we've taught people over the last 2 years to come up with something different that will turn your users off and will get people to just not want to use the software.
And I heard an analogy, which I think is apropos here, is one way to think of where we are on this generative AI journey is this is the AOL days of the internet. We're really early on. So it's hard to know how quickly this market will change, who the new vendors may come, new capabilities brought, and I'd hate to be still on the dial-up.
Yeah, no, that's definitely true. And we all know that, I mean, you're all lawyers. We all know that most of the lawyers we deal with are resistant to change, particularly in the technology they use every day. There's very few eager early adopters amongst this group, and they're greatly outweighed by the people that are frustrated because, the thing just changed from blue to red and they don't know what to do about it.
Lawyers don't get up in the morning and come to the office and say, I really want to learn a new piece of software today.
Right.
Okay. They just don't do that.
It gets in the way of billing.
Exactly. They want to finish the brief. They want to finish the contract, and anything that gets in the way of doing that is an impediment and a frustration, even if that tech-enabled solution would enable them to do it faster, better, cheaper.
Yep, absolutely. Well, let's jump to a different topic here, one that you've already started to cover, but I see from the questions that they're both interested in some of the same thing, primarily in training on prompt engineering in particular when it comes to generative AI. And before we go to you guys, I've got to tell you, yesterday, Womble had our third of what we have in the generative AI boot camp series. We're having 4 meetings. They're not required. Everybody's allowed to come, but I noted that there were over 200 lawyers or 200. Yeah, I think only lawyers can join. So over 200 lawyers at the boot camp this time, which was an hour on generative AI prompt engineering and what you should be thinking about and how it's different from search terms that you're used to using on Westlaw and Lexis. So can you guys talk a little bit about how your firms are doing this?
Well, you want to take first crack?
Sure. My personal bias is that training has to be situational and it has to be just in time. And you have to have tools that are available to solve for those 2 variables. So the training regime has to take into account how each of the particular trainees will use the tool, or there's the risk that the trainee will just tune out during the training. I think we are in a situation where law firms are going to have to create either subject matter expert in the short to mid term, either subject matter experts or Sherpas to work with the lawyers who are working with this tool as they gain familiarity. I am old enough to remember that when the law librarian gave us the keys to the castle, your very own Lexis login, right? They had to sit next to you to make sure that you were doing it correctly because it was so expensive for the law school to have that capability there. But that's how you learned Boolean searching. Now, presumably natural language processing is going to be a lot easier than Boolean searching. But I do think that having a Sherpa, having a subject matter expert, having a formalized system where people can get help is going to be essential to widespread deployment.
So if I can add, I think there's 2 points I'd like to share with you. So on our generative AI journey, it's been interesting is both the manager from the paralegal team and then also the legal library has voiced some concern. It's like, is this going to replace my job? I'm hearing great things about the AI assisted legal research. The paralegals heard about one of the use cases. I uploaded a 300-page document and it came back with a on-point summary. It's like, that's work we usually do. And I'm trying to spin this in such a way that this should be your opportunity. Embrace prompt engineering, become that expert in that field. If anything, this is going to open up more doors for you. Don't resist this, right? So I think that's one aspect of it that I wanted to instill at the firm is I'm not looking at this as a replacement for anyone's job. I would like to see this as an opportunity of new emerging technology and you becoming one of the subject matter experts because we're going to need that Sherpa. We're going to need people in that center of excellence once we go from an enterprise or from a small license to an enterprise license. The other aspect I want to share with you around prompt engineering is in the latest version of CoCounsel, which came out October, November timeframe, you can now use the large language model to help you create your prompt. So it might be something as simple as help me create a prompt to identify, we'll use my deposition example, to identify potential indiscrepancies or inconsistencies from the documents that I uploaded. And then CoCounsel, using the large language model, will actually craft the prompt for you and say, here's what I think you said. This is the prompt. Would you like me to run it? Yes. So I've been asking that. That's part of our foundational training is that as you're learning prompt engineering, the tool itself can help you do that. The other thing that we're doing is kind of coming up with a cheat sheet. And another analogy that I've been using, my daughter is a theater major in college, is that of a director and an actor. And I said, set the stage for the large language model. Tell it, I am an attorney. I just uploaded a transcript, a deposition transcript. I'm representing the defendant in this case. I'm interested in X, Y, or Z. Help me write with the prompt. But setting the stage for the prompt also helps us. But as we kind of alluded to, there is this trade-off of not being specific enough with the prompt and then being disappointed with the results that you get. So we're trying to learn through that, but that's how we're doing that in addition to formal training on prompt engineering.
One of the Garcia-isms is this is not the computer on Star Trek. Okay, we're not there yet. Someday we might get there, but it is not the computer on Star Trek. You're going to need to give it. You're going to need to give it more help. I think Peter's point about letting the existing staff know that there still needs to be a human in the middle of this is a very important point. We're going to have humans in the middle. They might have different skill sets from the existing paralegals. One of the challenges that law firms are going to have is upskilling or different skilling folks. And then the final point that I should have made earlier on the training is, I think that when you are evaluating software, part of the evaluation of the software has to be the nature and the extent of the training that will be necessary to drive the software. Again, if it's too complicated, people just aren't going to bother.
No, that's helpful to know. And one of the things that you raised there is the fact that we as lawyers, unlike other business folks, have professional responsibilities, and there are rules that define this. Do you work with your general counsel's office on this, or how do you develop sort of the ethical and professional responsibility aspects to making sure that people are using in your enterprise are using generative AI appropriately as lawyers?
Yeah, I can quickly comment that yes, the general counsel, in my case, Bruce has been one of my big partners in this and absolutely a stakeholder, and making sure that we are in lockstep as far as client notification. What does this mean to our engagement letters? How are we going to do this again in a responsible, ethical, measured approach is critical to our success.
And part of that, is confidentiality, which we've talked about a little bit earlier, but also the entire hallucination issue. Do you do training on that, or how do you let people know that they simply cannot depend on the tool to create something that you can hand into a court without review?
So our mantra is trust but verify these tools. So it's interesting too. Early on, we were getting questionnaires from clients asking us, in addition to using generative AI tools, will you share with us your use cases? And are you seeing efficiency gains? And then usually that's followed up with the next question is, will you be passing those cost savings on to us? It's like, we're really in these early phases right now. I don't know if there's true efficiencies because we're using the Gen AI tool, but then we're going back to the traditional Thomson Reuters or Lexis to double and triple check our work. So that's kind of where we are right now, Ted.
Bill, you had one of the things we talked about earlier when we were setting this up, or implementation landmines. I think people might be interested to hear some of that. I think people don't think enough, certainly lawyers, about bandwidth issues or tool inadequacy. What have you run into? What do we have to be careful of there?
Well, those are great things to think about. I think you have to understand the tool, understand the strengths and weaknesses. That's part of why you do the pilot. That's part of why you have 100 licenses to have people experiment with the tool. You can use a flat-headed screwdriver as a chisel. You can. I know. I've done it. It's not the best way to chisel something out. So understanding the right tool, understanding the use case for that tool, understanding what it cannot do, and then having the user base appreciate the strengths and weaknesses of each of the pieces of software, I think becomes a continuing challenge. We've talked we've talked about some of the bandwidth issues. We've talked about prompt engineering bandwidth issues. We've talked about the IS bandwidth issues for your technical support. I don't think you can underestimate the amount of bandwidth that is going to get sucked up in the first 6 or 8 months of deployment of these tools as people just begin to understand what is happening with the tool and how to support the tool. I am particularly interested in whether folks in the library and research services field can add a skill set of prompt engineering, for example. I think that within the IS function, you're going to need to find people to specialize in the support of these tools, particularly if, as I think you should, you begin to expand the tool to use it in ways that perhaps the vendor hadn't anticipated. That's the great experiment here, and that's frankly one of the big powers of the tool, is that ability to go beyond the box that the vendor has, the box that the vendor has created around the software, and say, okay, if it thinks in this way for this kind of problem, can we make it think in the same way for a different kind of problem, and get outside that box and be able to use it in a very different way than what the vendor had anticipated.
Yeah, that's excellent. But it also brings up something that one of the audiences asked about, which is you talk about use cases that might not have been anticipated. Can either or both of you discuss any specific stories that you know? I mean, obviously no names and clients or anything, but of using AI helped the lawyer in a case or a task. You have to hear this stuff, you're implementing it.
Yeah, so I shared one of them, which was the opposing counsel and getting ready for a deposition. I'll share another one that's related to that was, preparing the questions for a deposition. So this is a fabricated idea. Let's say we're deposing a CFO in a money laundering case next week. But the tool also is really extremely helpful in basically giving it a prompt. I'm an attorney. I will be deposing a CFO in a money laundering case. Help me generate questions that I should ask. And the tool will give the attorney topic areas. And of course, they could use them as is, or they can edit those or add their own. Once they're helpful with those topic areas, press another button, and it will give you 10 to 15 on-point questions that support that. So whether that's the brainstorming aspect of it early on, or I've already done that work and I'm using that as kind of a Q&A that I didn't miss anything, I think that's really, really valuable. Another example that we didn't know the tool could do was language translation. Now, we could not upload, let's say, a 50-page lease agreement that was written in German and have it translate it for us, but we could cut and paste different sections of it. And the part that we found out that really surprised us was it has a summarization feature. So we knew it could do 3 types of summarization. One would be a brief couple paragraphs. One would be maybe bullet points for every couple pages. And one could be a comprehensive summary where it would give you each page would be a summary, page by page summary. So we uploaded this German lease agreement. We used the summarize feature, and it summarized the contract for us in English and allowed us, the attorney, to basically assimilate what was in there without going through the time and expense of doing the full language translation. So that was one that surprised us. The other overarching thing I will tell you right now is our litigators are off to a much better start than our transactional attorneys. We did survey them at the end of November based on their 2 months working with the tool, and it was about 80% satisfaction from the litigators, less than 50 with the transactional attorneys. But as we dug into that, part of that reasoning was because we had one hand tied behind their back saying you can't upload your real client matter or your real client contracts, we're expecting to get much more support and hopefully get a big uptick in phase 2. But I will also share with you some of these early tools are more slanted toward the litigation skills than they are for transactional, with one exception. The Kiras, the eBrevia, the Luminous of the world, these are AI tools that have been typically used for M&A due diligence for 10 plus years. The generative AI tools have similar capabilities, so we'll continue to test that as well. But the ability to go through hundreds of contracts and extract certain clauses or provisions and then put them into an Excel spreadsheet and be able to answer the question, which of these agreements are going to be expiring in the next 60 or 90 days, and sort those by dollar amount. That's a use case that we think we can also pull off with generative AI, and we're looking at.
Ted, you're on mute.
Yeah, I just noted that. I'm sorry. Do you have any good ones, Bill, that are
Well,
interesting?
I think that using Peter referred to some of the document analytics AI tools that are designed for diligence, for example, and thinking about how those tools approach a set of documents, and then coming up with a set of documents that is not for diligence, but having enough examples that you can then train the tool, and using it sort of in the same way again that you would use a second-year associate. Read through all of these documents and tell me X about the documents. If it's a different kind of document, and I can't give you an example without sort of being obvious about who's involved. I would say that Peter's observation about litigators being more satisfied, I think, is not surprising, because the training set, if you will, for the litigators, case law, is public, right? It's out there, and the tools can be used. The training set on the transactional side becomes more problematic. How do you get a sanitized version of documents up into the tool to train? That becomes theoretically becomes a bit of a hurdle if you want to have a very large training set. So I'm not surprised at the results that Peter is finding.
Yeah, we're getting close to the end here. Let me throw out one that has come up with a few of the questions, but we're dealing with what it is that you have to tell people about using AI. In other words, there's a requirement under the model rules that you need to be allowing your clients to understand what technology you're using, but there are also some courts out there that are requiring notification if filings are being made that contain AI information, or were you done making AI. Do you guys have governance for this, or how do you make sure that all of these obligations are met?
This is something that we're talking about as we're just on the cusp of going into what we called phase 2. I will share with you, we're putting majority of the onus on the attorneys themselves and the client relationship partners to know their outside counsel agreements, know the jurisdiction they're practicing and any requirements. The general counsel's office is there to help them. But honestly, right now, from the AI perspective and being that change agent and champion for these new tools, I can't be a mini conflicts team and manage this aspect as well. So I don't know if I'm deferring this obligation. We're very cognizant of it, but it really is on the onus of the attorneys. Bill, I'd love to hear your perspective on this.
Yeah, I think that's right. I mean, I think it's going to be a continuing challenge to make sure that engagement teams appreciate the restrictions or the permissions of a particular client. But frankly, isn't that true of everything that's in an outside counsel guideline, right? The subject matter is slightly different, but it's the same challenge. I will say with respect to the court orders, Ted, I believe that it's Lexis that has just created a data set where they are going to purport to keep track of all of the courts that have entered orders, standing orders, with respect to disclosure of the use of AI or generative AI. But it's to me, it's the same outside counsel guidelines problem. How do you make sure that everyone on the engagement team understands everything that's in the outside counsel guidelines?
Yep, that makes sense. All right. Well, like I said, we're closing out I'm guessing you guys are going to have busy years next year. With all of this going on and whatever's coming up next. What do you see in the next year? What do you expect that you're going to be doing next year that you weren't doing this year, or that where your focus might change?
Well, I'm hopeful with all the testing we're doing, both on the litigation and transactional side, that we will come up with, I don't know what the number is, 3, 4, 5, 6 kind of key use cases that we really think can make a difference, and really make sure that our firm is excelling at those.
Yeah, like what kind of use cases do you expect, Peter?
Well, again, I'll go back to the first example I gave. The ability to upload deposition transcripts or use that in preparing for deposing an expert witness. That's something we didn't know, but I'm thinking that, that is really, it could be the difference in a case. It should be something that becomes in our own internal playbook of how we're going to approach these cases. So that would be an example, something that we see that absolutely can make a difference for our clients. Let's incorporate that. The other part that we're doing that I didn't get a chance to mention is on a weekly basis, all the users that are testing, we invite them, we call it an open forum, but basically it's to share these success stories. Here's the prompt I use, here's the data I uploaded, here was my legal issue, and here's the result. And this is why it's important to us. And having that forum and trying to build that enthusiasm and also kind of grow these internal champions has been really important to our success in trying to get to phase 2.
Well, and it reminds me, before we get to Bill, of how doctors are using AI in a lot of cases, in that, you know, your radiologist is going to be looking at the X-rays, but they'll have the AI looking at it as well. And the AI may well catch things that the radiologist didn't, but we need to have both sets of eyes on it. And, you know, it just gives you another way of making sure you're doing a better job for your client. Go ahead, Bill. I'm sorry.
It's okay. Yeah, again, human in the middle. I think that is going to be essential. I don't see this technology as job destroying. It's going to be job changing for sure. You know, we used to have an entire industry of farriers. No one shoes horses anymore, but we have plenty of auto mechanics. So over the course of the next year, I think we're going to see turmoil throughout the year as things settle out. I think we're moving off of irrational exuberance about generative AI, or what Gartner calls the peak of inflated expectations, towards what they call the trough of disillusionment. But we're a long way off from the end state plateau of productivity. I think we're going to be moving along that curve through the trough of disillusionment as lawyers become disappointed that it's not the computer on Star Trek, and it is going to require a fair amount of understanding of the tool, or at least asking people who do understand the tool for help.
No, that's perfect. And a good way to end, I will quote, I'll make a quote. I'm just telling you because it's not mine. I don't remember who said it, but that they doubt very much that lawyers are going to lose jobs to AI. What they are certain is going to happen is lawyers are going to lose jobs to lawyers who know how to use AI. And so that is something we all should be watching for. Well, thank you both. I really, really appreciate your phenomenal expertise and your willingness to share what your large law firms are going through with this. I will hand it back to Joey so that he can give us our program notes.
Yes, absolutely. Thank you to our panelists and our moderator for an incredible event today. This was really, really fantastic. One of the questions in the Q&A is how can the ABA help provide lawyers more information on this? And I would always, as a starting place, please check out the ABA Task Force website on this. It is full of resources, tools, articles that can help lawyers get a starting point of this. As always, today's event is from the ABA Task Force on Law and Artificial Intelligence. The comments of our speakers today have not been approved by the Board of Governors or the House of Delegates and may not reflect the views of the ABA. We have two great events, one tomorrow at noon, one tomorrow at 8 a.m. Pacific, 11 a.m. Eastern. This is AI Governance, a conversation with Miriam Vogel, who is the chair of the National AI Advisory Committee. And on Monday, the 22nd at noon Eastern, we will also have one of the lunch and learns from our judges working group, working on courts and AI, and this will be the impact of deepfakes on the justice system. We hope you can join us for either of those events. And again, thank you to our panelists and our moderators. Today's webinar will be available early next week on the AI Task Force website. Thank you.